Good evening and warm welcome from the team at Daksha Fellowship to this Daksha Masterclass on forest rights legislation, stocktaking of human rights of indigenous people in India. It is my pleasure to introduce our speaker for today, Dr. Suchithra Menon. Dr. Suchithra Menon is an assistant professor of law at Sai University and faculty at Daksha Fellowship. Dr. Menon has worked closely with Government of Karnataka and Government of Rajasthan on water and irrigation laws. She conducts gender sensitization workshops for government officials in Kerala and gender sensitivity at workplace sessions for corporate participants at various institutes. Professor Menon has been a trainer and resource person for various organizations such as NADT, NACEN, and IICA. Her area of interest includes public law, human rights, consumer law, and employment laws. She has published several articles in edited books and journals. She regularly contributes pieces to media, including The Hindu, The Print, and Live Law. Before I hand the session over to Professor, I'd like to remind you that all participants in the session are on mute, but you can post your questions and queries in the Q&A box, and we'll take them up at the end of the session. You can use the chat box to respond to polls or questions posed by a professor. With that, I hand over the session to Dr. Suchithra Menon.
Thank you for that warm introduction. It is indeed my pleasure and happiness to be with you all today. I welcome all the participants, and I'm sure that Daksha as a platform, you would be much more similar because we have brought before you the Daksha master classes, the Daksha decision, the data and decisions week, and so on, and with the sole intention of engaging with people. So with that note, let me start with what is it that we are talking about today. So before that, just let me start sharing the screen so that I've made a presentation so that we are, yes. Are you able to view the screen? I've started the screen sharing.
Yes, Professor, we can.
Great, yes. Great. So the topic of discussion, or what is it that we are looking today? What is it that we are discussing? The topic is that forest rights, or we are looking at how forest rights legislation, how that has certain human rights implication. What could be the popular mode of governance, or is there a shift in governance that is possible? So with that sneak peek, let me move on to the presentation. I must appreciate the enthusiastic crowd that has joined us. And I'm sure that for this crowd, would it be possible, can you give it a shot that, can you identify who these people are and what is their relevance with regard to forest right or human rights in particular? So you can post, or is the chat option available for the participants?
Yes, Professor, it's available.
Okay, great. So in the chat section, kindly mention that who are these people and what is the long legal battle that they fought. I just have I'll provide for 30 seconds and you can provide for your enthusiastic answers. Yes, the answers are coming in. Great. It is interesting to see. Of course, yes, you have identified it correctly. It is the Dongriya tribe. And the case, or the long battle that they fought, is the Nemagiri case, or the Vedanta case as it is popularly known as. Why is it that this narrative becomes significant, or why is it that this is critical? What is the relevance of the Dongriya tribe and Nemagiri? And what is its interconnection with the forest rights legislation? Let's start. So the case, or the whole set of the legal, it starts with a narrative. Vedanta Resources, one of the companies that are registered in the UK. It's a UK registered mining company which operates through its subsidiaries, one in India, and it has the in 2004 the Vedanta Resource, or the Vedanta Resource Mining Company, signs an agreement with the Orissa Mining Corporation. And what is it about? It is to open a mine which has bauxite and aluminum and such other industrial requirements. And in 2008, the Supreme Court, the Honorable Supreme Court, granted the approval with a rider or with a condition saying that you need to get the environmental clearance done. And for this purpose, the ministry sets up an environmental panel, a committee, and the committee looks into the matter and gives a negative report. In 2011, the Orissa Mining challenged the same in the Supreme Court. In 2013, the Supreme Court ruled in the mine in Nemagiri Hills are valid. And it is also in that context that the Ministry of Environment and Forest decided not to allow the project. In 2016, the Supreme Court blocked the attempt by the Odisha state government that the referendum that had applied before isn't valid, or there are certain flaws. Why is it that I give a summary? It is just to clearly state that how the religious rights or the indigeneity of the community was identified and recognized by the Supreme Court, stating that the indigenous rights are significant when it comes to the decisions or the agreements that are made. It is the people's participation, the voice of people needs to be visually identified. So this is the story, or this is the start story where we would say that, to gain your attention or to attract you into the to the readings of indigenous people. So the indigenous group questions that how do we identify who are these people? Who are the indigenous people? So this is just a snapshot of what is it that we will be covering today. We will give you an overview of how indigenous rights in India, legal and policy developments, and out of which the Forest Rights Act 2006 is for consideration, and how we look into probably what are the challenges that are faced, and how probably there are certain elements of environmental governance that could be taken, or there could be possible changes or certain approaches, different approaches that could follow the line. So this is just a snapshot or the synopsis of the presentation. Who are these indigenous people that I'm talking about? And I'm sure as people who are interested in understanding the tribal rights or indigenous people right, you would have seen how probably indigenous peoples are also significant. You would have seen how indigenous people, certain areas it's written as people. It could also be Adivasis or Vanavasis that are written. So there are a lot of situations where you would see that so what are these terminologies especially? So to begin with, it is the Ministry of Tribal Affairs or Tribal do provide for a statistics which notes that the 8.2% of India's population is identified as Adivasi. It is also in terms of 461 ethnic tribes, and there are additional few tribes which go unrecognized, or technically speaking not under the schedule, not because of any other reasons. It's for the administration of such tribes or such concerns. And the constitution also lists certain tribes but does not define the term. And in that context, let us look as to how indigenous people in the international context and how that is relevant. So in the international context, if you look, the indigenous people, or the most significant document that you would find is the UN Declaration on Indigenous People. 2007, and it becomes critically important to identify, how is a declaration. So as people who are interested in human rights, you would have also seen how declarations are significant, or what is it that declaration, when it comes to the hierarchy of the various international documents, of course declaration do not stand so high as a convention or an agreement. True, it is. But of course, the declaration itself is identified one of the key elements. For example, if you look at the United Nations Human Rights Declaration, the declaration is, of course, yes, that is a declaration. It's a mere declaration declaring of certain rights. But significantly, that is the first stepping stone in terms of human rights. So in the same lines, of course, the declaration for indigenous people holds certain specific principles, out of which the key principle being self-determination. Self-determination is nothing but to manage their own resources, or to participate, or have a feeling that it is your own resources and you're managing it. And also in terms of understanding community or group rights. So that is the significant, one of the key features that we would say. Does it stop here? No. The that we're discussing, it is also critical because it is not only that the UN declaration, but the International Labour Organization, popular document being the number 169, where it also talks about definition of indigenous people. And why I would say that, defining becomes a little problematic, because of the simple reason that we technically do not have a specific the definition, exact definition of indigenous people. And why I would say that, for example, if you look at in terms of identifying the definition, the Jose R. Martinez Cobo, the familiar name in terms of the special rapporteur for the Subcommission on Prevention of Discrimination and Protection of Minorities, in his study of problems of discrimination against indigenous people, tries to provide, or the key terms that he identifies as to how indigenous people are identified includes the occupation of the ancestral, at least part of them, common ancestry with original occupants, culture in general, or specific manifestations of such as religion, living under certain conditions, membership within a group, language, or residence, or other relevant factors to identify. In the international setting, of course, when we say that these are the few parameters in which that indigenous people could be identified, in the Indian context, it is referred as Adivasis or Vanavasi, and also there is no one set of people that could be described. And this is also in terms of how indigenous people, or how we do not have a one set of definition. So for this presentation, of course, I have mentioned that the terms are used interchangeably. And now that I've sufficiently bored you with identifying who these people are, let us move on to identifying what are the rights that are associated. And in terms of rights, specifically in terms of how social, economic, political rights are seen into. Of course, yes, I understand that when it comes to the educational, cultural rights, Article 15, 4, 29, 30, 46, all of these come into picture. And also in terms of social rights, we have Article 47, 23, and 24. And in political rights, of course, yes, 164, 1, 243D, 332, so on and so forth. And in terms of employment, special privileges or special considerations are provided in 15.4, 16.4, 4A, and 335. And also, please remember that Schedule 5 and Schedule 6 also forms part, or that also provides for certain administration of the and in terms of Schedule 6 being specifically in terms of certain tribes in up in the northeast. So this is just to give you a rough idea about how it is. And of course, yes, we also understand for the welfare of the indigenous people, we also have the National Commission for Scheduled Tribes and the ministry and such other government which would also takes care of the welfare. Now, coming to the Constitution, so we have given you a brief about how constitutional rights are associated. Then comes the legislative rights. What are the specific legislations? Protection of Civil Rights Act, the Scheduled Caste and Scheduled Tribes Prevention of Atrocities, of course, the Forest Rights Act, or the technical term of Scheduled Tribes and other traditional forest dwellers, Recognition of Forest Rights Act 2006, and the Panchayati Raj legislations. The Panchayati Raj legislations becomes key important factor because, of course, yes, the Gram Sabha, and I'm sure that you would have followed how the Forest Rights Act of 2006 also recognizes the role played by Gram Sabha. So this is just to give you a background, and in context, I would specifically take you through the Forest Rights Act and how the governance of forests and the so to give you a background about the Forest Rights Act. The Forest Rights Act, of course, yes, it is the legislation which talks about the rights of the forest dwellers, and it also talks about how these rights, how in terms of what are the that are generally involved, or why it becomes. So the story goes a little back. I mean, I'll take you to the prehistoric era where the pre-British era, where it is the idea of forest, or the revenue that is associated, or how forest becomes important. Like the adoption of Forest Rights Act is acknowledged as a rectification to the historic injustice accorded to the forest dwelling indigenous community. And how do I say that? The Indian Forest Rights Charter 1855, of course, that is, and it is earmarked in terms of the teak and timber as to government property, because the British ideology involved that how probably forest is also part of revenue, or the timber or the forest products are significant in those matters, and how there should be the exclusion of community in terms of all of those. So that is a different context and all. So the British era, or the idea of how forest and its people exclude the Charter 1855 later molded to the Indian Forest Act of 1865. This colonial legislation and its modified form is still in terms of the edifice of the forest governance, the Indian Forest Rights Act of 1927. And it is significant, or in this context, we can also look at how Ramchandra Guha, eminent scholar, tries to explain that forest legislations in the pre-independent India are also aligned with the imperialistic nature of the British government. To set the stage and to identify how forest-dwelling indigenous community has evolved its ritualistic practices. And in terms of the 2006 legislation, there are certain key important points of how the forest dwellers. So the point here is to identify how the growth of the forest legislations, or forest the legislations come into picture. You have the Charter, we have the Indian Forest Act of 1927, and the forest dwellings. Of course, the policies do play an important role at that point of time. And the 2006 legislation, of course, has certain key features. As I have already indicated before, the Forest Rights Act, it recognizes a set of individual and community right for forest dwellers, and significantly identifying the pre-informed consent. And it is also significant to note that how Gram Sabhas being determine the nature and extent of individual forest rights. And it is in this context that how Nemagiri and how the Supreme Court recognized the Dongria right, or the right to worship this sacred mountain which needs to be protected, also becomes important. So when you look at the legislation, the key principles or key elements that include is that how the question of the act recognizing and best forest rights and occupation of forest land for the dwellers, and in terms of how responsibility and authority for a sustainable use comes into picture. It also looks at how the rights are also extended in terms of identifying these the terms of relief and developmental rights are looked into. So in this context, so the 2006, I'm sure that the 2006, from 2006 onwards, what is it that it is recently that is required? The most important concern when it comes to the Forest Rights Act is, of course, how well that can be implemented, or what is the current status. Of course, there are certain specific concerns that we identify here in these lines. That is how there is an issue of implementation of Forest Rights Act in terms of, if you look at the example, for example, if you look at how Himachal Pradesh, certain claims. So in the Forest Rights Act, where there are certain claims that are made to identify the forest dwellers and their rights, it could also be that the question of how the claims are settled, and the state governments also critically see that these claims aren't clearly identified. So here what happens or in terms of how implementation of Forest Rights Act come into picture, I'm sure that we are also aware about how 2019 how there was the issue of the certain groups from the without the claims, or the Forest Rights Act also specifically say that you have to show for the claim there is a specific timeline that is given to show that you have a certain claim, and that also becomes problematic. Of course, those lines, and in terms of identifying these claims over the forest land, the three main concerns over the implementation include the lack of administrative action, and this is also evident from the examples that are provided even from the states of Himachal Pradesh and certain areas in Kerala as well. So these contexts, of course, yes, there are certain statistical studies that are done by certain groups, which also shows, of course, that's up in the ministry website itself, where it says that, for example, if you look at 2018, the state of Himachal Pradesh, the revenue villages, or the claims that were made is somewhere around 2000, and the title that were issued, or which they technically is 170, and the title issued includes only 7 of them. So we can see a drastic reason of how there has been serious concerns. So of course, the Forest Rights Act has the ideas of promotion of community rights, free, informed, prior consent that needs to be taken by the community, and it also looks into the aspects of Gram Sabha. And of course, in those terms, the Niyamagiri case or the Vedanta case is one significant aspect where or the Supreme Court, Honorable Supreme Court, recognized these rights. In that context, I would like to this is just to give you a brief about what are the genuine concerns that are, or to give you who are the indigenous rights, who are the indigenous people, what are the rights that are associated under the legislative banner we have, or legislative rights we have. We are looking at the Forest Rights Act, and out of Forest Rights Act, when we look at what are the concerns over the implementation. get a small break, or if you have certain questions or queries, because the next is about how to overcome these implementation issues, or what are the possible methods of governance that needs to be identified, how there are a governance pattern that can be looked into. So this is so in this, if you have certain questions, you can kindly post it on the Q&A section. I'll pause for a minute, take your questions, and then go forward for the presentation. Yes, I think the questions are coming in. I'll quickly move on to the, I think, the questions that are provided. Okay, so I think I'll take the questions a little later, because questions are coming in. So probably I'll take the questions on the next section probably. Yes. So can I go back to the presentation? Can we continue the discussion? Of course, this is not a discussion in that right sense, right? So can I go back? Okay, great. Fine. Okay, there has been a question as to how international law, or how what is the author's name? Of course, yes, I'll type that answer towards the end of the session. I'll provide for the answer. Okay, great. So going back to the presentation. So now about the, sorry. Now that I have given you a brief about what is the legislation, the concerns, and so on and so forth, what could be the possible method of overcoming such situation? The most significant aspect that is identified in terms of in the terms of regulation is that adaptive co-management. And how adaptive co-management becomes significant is because of the simple reason that it has foundations in the convergence of two concepts of adaptive management and co-management. So the simple, or the broad structure is that when it comes to community, it is not only that all the stakeholders need to be taken into consideration while you reach or while you argue, but it is also on these terms that certain situations may require adaptive management. And it is also identified as a part of experimental governance. And I'll run you through as to how the adaptive co-management becomes significant in terms of forest governance, especially. Like in this context, so when we looked at the Forest Rights Act, we realized that of course there is a there is a power structuring that is being done. There are certain elements which they try to, the legislation itself brings into picture to reduce the command and control. But the nature of the nature of regulation transforms itself in adaptive co-management to a multi-actor, or a multi-level of governance. Multi-governance comes into picture. And it is because of the main, or the key aspects include that non-state actors, or in terms of the exact terminologies when it comes to the stakeholders, growing importance of market, the rise of new socio-economic groups. It could also be multi-scalar policy that comes into picture. It could also be in terms of increase in the involvement of the legal and judicial arena. In terms of adaptive co-management, for example, see, the issue here is in terms of identifying what is adaptive co-management. In a given situation, it may not be that you have multi-stakeholders that come into picture. It is not only that you need to keep them into loop, but there would be certain critical situations. Like, for example, one of the key articles that talk about how adaptive co-management is significant in ecological complexities, to reduce these complexities, or how that can be taken into consideration. A simple example that is provided is probably when it comes to the situation of a hunter's knowledge, or the hunting party on an uncertain sea ice condition. That is, this is in terms of how the adaptive co-management on in terms of fisheries or water bodies. But this example is provided that when you are skiing through, or when the ship travels through a sea ice, the traditional knowledge of a hunter or a dweller would be, the community would have a greater knowledge, and that knowledge can be adapted in such a manner. So the recognition of the adaptive co-management is significant, and it is also identified, it is also identified as one of the part of experimental governance. And why I would say that, of course, yes, I'm sure that when it comes to forest governance, forest management, the key thing that comes into mind is joint forest management, of course, yes, but it is also identified as in the larger context, or at least I would identify the element of experimental governance in terms of the joint forest management is, of course, an example in which that you can say that, of course, there is elements of adaptive co-management coming into picture. So the next question, so once when we say that there are certain or the model can be, model is identified, or a right term that could be possibly where you have collaborative learning, you also have multi-stake approach that comes into picture. It is no longer, it is also a learning experience through which the problem can be solved. In those terms, the experimental method. And this is, of course, in terms of forest governance, we have experience from the Africa, where they would clearly say, or like in the experiments that were conducted in terms of adaptive co-management, say that the key points or the positive aspects include there have been effective forest management, and the social learning, collaborative and adaptive thinking is how the problem has been solved. The increased stakeholder participation in the development of strategies of management being the key points. So the model has been tested in terms of the East Africa, Western Africa, and there are certain key elements. So the common points are that there has been, of course, yes, when the community is provided with the right, or when the community is taken into confidence when these situations arise, there are effective forest management. But on the contrary, when you see the ones that are marked in red are those which are considered as challenges that are generally faced in terms of the adaptive co-management approach. It is, of course, the state administration and bureaucracy in terms of how there are situations where they could be pursuing their own agenda, and lack of initiatives of forest administration, lack of incentives for the forest administration, community priorities and lack of effective participation of the community. So I'm sure that you would be thinking that, okay, one side you say there is effective forest management, but on the other side you say this is also one of the challenge that the community faces. How is it that the community doesn't get factored in? So here, what I would technically suggest and play, that this was something that I should have mentioned to you on an earlier note. All the examples or all the references that I make, I have noted it towards the end. So it is just to give you a brief, and then references are provided towards the end, wherein you can refer and figure out, and we can, of course, engage in a constructive conversation later, probably. So the key element is how there is a lack of initiative of forest administration, or how possibly initiatives and incentives are not provided. So when the community is taken into confidence, when there is collaborative learning, the effective forest management happens. And of course, we have the example where we can say Nemagiri is one of those examples where, of course, it had to have a legal battle, but how the community knowledge of communities, the community as a whole, the indigeneity of the community had to be identified. And it is in this context that I would say that these are the critical experimental models, and the experimental governance is the next key thing, or like, when it comes to the factor of regulations, these are certain specific issues. And so this is just to give you an insight, or when it comes to today, as August 9th is International Day of the Indigenous People, and it is just to know more about how probably different models can be tested, and one of the key elements being to adapt or to respond to a situation where you have collaborative learning with multi-stakeholders. So this is just a sneak peek to the ideas, and these are certain references that are provided in terms of knowing, or how the significance in terms of how the indigenous peoples, right? And of course, yes, I can take the questions at this stage if there are any, and these are some of the references. Of course, the celebrated works include Ramchandra Guhas, or for that matter, Sharat Chandra Lele, and even Nandini Sundar, how articulatively they have written about how indigenous rights and how forest rights, and specifically, can be well established or can be conserved, or in terms of how possibly there could be aspects of adaptive co-management. And I've provided for a detailed review of how positive elements, or the examples also provide for positive, but so negative challenges, or the challenges that are faced, which is yet to say that, like, the model of governance that is required, of course, is collaborative in nature. It should adapt and respond to the situations. Yes. So yes, I have received few questions. Okay. The new okay. Are you able to hear me?
Yes, Professor. We
Yes.
are
Okay.
able to
Okay.
hear you.
Okay. Because there is some fluctuation that it is showing. So in those terms, of course, yes.
Yeah.
So the first question being, of course, yes, I'll type the answer later. Ankita had asked that, about how the author, who's the author who is classified in the identification of, I'll answer that a little later. The first question being how the EIA draft has widely been criticized on the ground that public consultation has been removed, and offer a post, just a second. I just have certain connection issues, I believe. So I'll just read out the first question. The new EIA draft has widely been criticized on the ground that public consultation has been removed, and offer a post facto clearance to the project. In the light of these premises, does the draft notification threaten the rights of indigenous community? I must say, of course, yes, because the key element is about how community participation, and how we are looked into that, how how community has to be taken into consideration when adaptive co-management. It is also sad in those lines that the draft Forest Policy 2020 also do not have certain, it does not significantly reflect in terms of adaptive co-management. So when it comes to managing the system, or how possibly that could be looked into, that or situations, of course, yes, and it is critical to have participation, and the participatory approach, it is required. Even in the international context, we can see that how there are critical examples of how participation, or how community is taken into consideration, participation, significant. And I must mention that it's quite nice of you to mention it here in terms of how these questions are looking into. Okay. And how possibly the participation is significant. Next, so their tribals have so many rights, but these people are unaware of reforms. No reforms have reflected. How can we help these people as a budding lawyer? And as I've seen, tribals still are at the same stage. Okay, fine. So the question is about how possibly that we could look at the how tribals, or how questions of how we could help them in that context. So in this, I would definitely say that it's quite nice of you to see that how budding lawyers are interested in those lines. I must say that there have been, like, situations of, there are the organizations that work for the providing, or there are certain specific organizations which work for the tribal conservations. And of course, I can see that, like, as a budding lawyer, it is essential to work with and also to write extensively on terms of indigenous rights and how possibly that could also help you. I'm sure that, like, the especially when it comes to forest rights, we of course have these questions of how tribals need to be educated, and how probably we could provide for certain specific legal issues or legal possibilities of doing this. Of course, yes. Yes. So there have been questions on how possibly, what is the question of how the study on how the doctoral study. Of course, yes, I've provided the references that has been provided. And of course, yes, I have mentioned that in terms of the when you talk about forest management, or forest adaptive co-management approach that has to be done, it is an experimental one. And of course, we have looked into the cases of African experiences in those lines. Of course, this is a doctoral study, and this is just to give you a rough idea about how possible structures of governance, or how possible structures of governance is significant in this aspect. So I think questions. Are there any other questions? Okay. Yes. Okay. Fine.
Yeah, Professor, I think, do you want to wait for some more time for questions?
Yeah, sure,
a few
sure.
coming in.
Yes, sure. Yeah, so there have been questions of how, why other, why indigenous law, probably US laws are not something that we can look at. Of course, yes, that's because it's a significant reason that the aspects of how, when we say that, okay, this is how certain laws are implemented, or certain questions are to the interesting aspect is that certain, when you look at the law in toto, we also look at the background in which the laws are implemented. Of course, the situations in the United States may not suit that exactly in those lines. I've looked at only specific issues of how the forest legislations are provided. So in that context, we may not be able to provide for significant examples in that context. Thank you for that wonderful comments. Yeah, thank you so much for your it is, of course, we cannot engage in the discussion in that nature, but thank you for your enthusiasm.
Yeah, Professor. So I think we have come to the end of the session. We are not receiving any questions. I think they would also write us. They can write us at outreach@dakshafellowship.org with any queries. Sure. We can respond back with answers. Professor.
Yeah, you can also provide for my email ID, suchithramenonc@gmail.com. That is also in case you would want to discuss more about this. Of course, yes, we can.
Yeah, so you can also write to our professor. She has given her email ID, and the response would also depend upon the number of queries, and you might get response in a day or in a week. So please bear with that, right? So, Professor, thank you very much for this very interesting and informative talk. Our thanks to everyone who took time to attend this session. For all the students attending today's session, our final round of application is in progress. We look forward to having your applications for the Daksha Fellowship. If you have, as I said already, if you have any additional questions, do reach out to us through the contact us form on our website www.dakshafellowship.org. You may also choose to write us at outreach@dakshafellowship.org, or you can make a call in a number 99400 57400. Thank you very much.
Thank you.